Better. Okay. I'm Christine Hawes, Vice President with the Trust and Investment Management Department at Charlotte State Bank and Trust. So I welcome you here this afternoon. What a great seminar, right? Great session, great conference. Chris and Amy and Sophie have done a great job, so we're just, and the team. So we will talk a little bit about will versus trust. Just so you know, we do a series of seminars at the branches, especially October through April. But we're also doing a summer seminar series. So next week we will be in Murdoch, our Murdoch office up near Sonny's Barbecue, on Tuesday, Wednesday, and Thursday, morning and afternoon session. So you can visit charlottestatebank.com website, and all the information is there. You can do it from home via virtual, or you can join us live. Then next week we will be here in our Punta Gorda branch, the week after that. So next week Murdoch, and then the week after we'll be in Punta Gorda. So you're welcome to join us anytime. They're free, open to the public, all educational. And we do them for an hour and a half. So this is going to be the Blitz quick version, but we always do a normal hour and a half session because people have questions and answers. We want to get to those. So we shall advance. So some of the benefits of estate planning, building in those safety nets. Creditors, divorces. If my dad leaves me $500,000 in an IRA and I get into a car accident the week before and Morgan & Morgan are suing me, I got a problem, don't I? Because now that IRA he left me is in jeopardy. So we always talk about how to plan for the next generation, how to transfer wealth appropriately so that if somebody does inherit money, they don't lose it. Saving on probate costs and settlement costs, as opposed to Robin's mode of how they do business. We don't hire legal counsel to do estate settlement. Unless it's probate, we may hire by the hour just for a few hours of legal work. But as trust officers, we are all trained to do that type of work. So it's a little different model. And that's important because, when you're looking at $1 million estate, every time you add 2.25 as a fee on top of that or 3%, it gets really expensive. So our mandate as trust officers and fiduciaries is to keep the cost down. We want more money going to your beneficiary, so we think that's important. Keeping privacy of your final plans. Are wills public record? Anybody know when you die, is your will public record? Yes. By law, the custodian within 10 days must file it with the courts with your death certificate. Does that happen in a non-trust officer world? Probably not, but in our world is very important. So when I'm dealing with couples and I know one spouse passes away, the first thing I think of is I've got to get that will out of the vault and get it into the hands of the spouse or the attorney so that they can file it with the courts. And that's a protection about fraud, which is very important. Keeping control of your assets, especially through incapacity, and that's where we think the trust is a little more beneficial because then you've got someone to step in to take care of your trust assets and to monitor your property, pay your taxes, take care of your insurances, all those things. Because, a lot of people think of wills and trusts just for death, but there's that gray time in between, when you're out petting the alligators. Not so good, right? So we have to be careful and kind of plan for that gray time. Estate tax planning. Anybody know how much you can die and be worth this year and not pay Uncle Sam on your estate? $11.7 million per person. Now, Congress and the current administration was talking about 3.5. If they don't do anything in 2025, it rolls back to 5 million something. So, we do have clients in that situation that we have to plan for. And that's important because you can only have one chance to get that credit, so you have to make sure you use it. Selecting the administrators of your will or trust, that's important. In our world, we don't believe that a family member who is a beneficiary should also be an administrator. Anybody want to define conflict of interest? Right? So if my father leaves $500,000 in trust for my stepmother, Mary, and he says to my brother, John, you're in charge of that $500,000 bucket. Your job is to take care of Mary, and whatever's left is for you. Is Mary going to go to the best nursing home? Is she going to have the best care? No. So it's an inherent conflict of interest. We like to make sure that administrators are not beneficiaries. It doesn't bode well. Provide the appropriate support for family and loved ones. We have a lot of parents who are planning for children who have bipolar condition or physical ailments, grandkids with autism. I mean, there are a lot of special needs situations, drug, alcohol abuse, shopping. You know, that little Amazon guy comes every day. Guess who pays for that, right? So we have to kind of plan for things like that. And sometimes my clients will tell me, listen, my son or daughter is great with money, but the person they married is not. We have the in-laws and the outlaws, right? So we have to plan. So some of the documents you'll get when you go to the estate planning attorney, and I help people through this for free. I'm like the estate planning tour guide, for lack of a better term. And everyone will get a last will and testament, everybody, your own. Some states do joint. We don't do that in Florida. So I have my own will. My husband has his own will. That's how it is. Then some will have the living will and designation of healthcare surrogate. That's a mandated, really, document for anyone who does estate planning, because you want to make sure, and I'm going to do a session after this on living will versus DNR, but the living will is where you do or do not want food or water at the end of life, and you have to state that. Then the healthcare surrogate is empowering someone to make medical decisions for you. So if I become unable to communicate, they take me to the hospital, and my husband comes to the emergency room, and they don't know that he's my designated healthcare surrogate with a HIPAA privacy waiver in the document. They're not going to tell him what's wrong with me because of HIPAA privacy. But if he presents to them the documents, which we of course have, it says, I'm Jeffrey, I'm Christine's spouse, and she has given me permission to speak openly with you about my medical condition, about her medical condition. So that's important, very, very important. Otherwise, you're making decisions without any knowledge, right? That's not good. Then we have, of course, the durable power of attorney, and that's what keeps you out of guardianship court. And I'm sure Robin, those of you who sat through Robin's session, talk about, if you have a good power of attorney and you've named the right people, you're okay. Now, how do you determine who's the right person to be your agent and your power of attorney? I have a simple rule. If you don't leave your wallet or your purse in the room alone with that person, do not name them. Because in the wrong hands, a power of attorney is a license to steal, right? And legally. So just be real careful. And then your revocable living trust is appropriate for some folks, usually when it's over $500,000 of an estate size. That's one indicator. If you're going to be alone and have no one watching over you in your later years, another good reason to have a revocable trust. How about if you have real estate in 2 states? Another reason, because you want to avoid probate in the other state and in our state. So that's important. Some estate planning terms, last will and testament. Just really generically, it's giving the judge and the courts your roadmap of where you want things to go and who's going to be in charge. You can change it with a codicil if you change your mind about something, who's getting what or who's in charge. And then the revocable living trust is operative during lifetime. So that gives me peace of mind to know I have a trust during lifetime to give me extra protections during incapacity so that they're not depending solely on my power of attorney or solely on my health care documents. So it gives somebody the ability to name a successor person or entity to step in and take care of property, especially real estate, business interests, investments, things of that nature. And then you can change that, of course, too, during your lifetime with an amendment. So a simple document doesn't, cost as much as the whole trust. It's just a fractional cost just to change a piece of that trust. So it's very flexible and amendable and changeable. So will versus trust, which one should you have, right? Always a good question. When you have a blended family, we're in the land of second and third marriages, aren't we in Florida? I know I'm in one, so I'm sure that's just how life is, right? 60% of marriages end in divorce. So a lot of second marriages. Well, when that happens, you might have assets that are heirloom or family legacy assets that you may want to go to your children, not your second spouse or third spouse. So how do we plan for that? Again, the trust is probably a better avenue, and there are maybe separate trusts that might be invoked. Because think about it. If I have an IRA worth $1 million, and I put my husband as the primary beneficiary of that IRA, but let's just say, for example purposes, I have children from a prior marriage. Would I want my husband to be the beneficiary of my IRA? Because what's he going to do when I die and he inherits that IRA? What's the first thing he's going to do? Put new beneficiaries on it. Do you think it's going to be my children? Probably not, right? Because I'm the glue that holds him to my kids. And when I'm gone, it's gone. So 9 times out of 10, that's the way it happens. So you have to be careful with the blended families. Privacy concerns, another big issue. Because remember, wills are public record. So if our wills look alike and I die first, the looky-loo relatives or neighbors can look in and say, wonder who's going to get the money when the next one goes. And then they start to put pressure on that surviving spouse. So you have to be real careful. Family business interests, that's always interesting. Couples with children or without children, either one. You really have to think hard about having a will, which is really just a simple direction of where your assets go through the probate process, or avoiding probate with the trust. Because that saves a lot of money. I know if we die together, God forbid, our exit cost is 2.25%. Versus if we had a will, it would be 6 to 8%. So what would you rather pay, 2.25 or 6 to 8? And the reason ours is 2.25 is because we named the bank, Charlotte State Bank and Trust, as our successor. So when we die, if we happen to die together or the last to die, the bank handles everything. And again, they don't go hire legal counsel, so it keeps the cost down because we as trust officers are trained to settle estates. We don't need to hire other people because that gets expensive. Two choices of the trust. You have your revocable and then you have your irrevocable trust. Be cautious with the irrev trusts. You'll lose a lot of control. Make sure you do it under good legal guidance. You know, lawyers have an excellent purpose in life, right? And they help guide us. But we have to be cautious because those irrevocable trusts are tricky. So make sure you have good legal coverage. A trust allows for probate avoidance, as we talked about. And remember, that's a public, right, time-consuming, expensive process. If you can avoid it, please do so. Because it's expensive. It takes time. Like, we drive by a house on the corner of our street, and my husband says, how come no one's sold that house? I go, it's probably stuck in probate. Because Lillian probably didn't have it in trust when she died, and now the kids are either fighting over it, or they're having to go find 2 witnesses on a New Jersey will that she signed 30 years ago. You know, something crazy is happening. And it happens all the time. So a trust can provide maximum protection during that time of incapacity. So I know that if one of us starts acting a little wonky, the bank will step in, make sure our money is managed right, make sure the taxes are paid, insurances are paid. You know, everything that we normally do, all of us on a daily basis, is done for us when we're in that time of incapacity. And that's important. Keeps you out of a lot of trouble. And I know that our trust clients that we manage, you know, their money, their lifestyle, take care of them. I know that they're never going to fall for a Nigerian lottery scheme or the Canadian lottery scheme or my grandkids in a Mexican jail scheme, because we're not going to let that money out. And actually, our bankers are really good at not letting those frauds happen either. But the trust department, certainly that money is secure. And that means a lot. And sometimes, you know who we're protecting money from? From the person's own family members. And that's the sad part. But it happens. So factors to consider: cost versus savings. Costs a little more to have the trust, maybe $800, $1,200 more, but you save tens of thousands of dollars depending upon how big your estate is when you start doing that math of 6 to 8% versus 2.25 or even 4.5%. So when you do the math, you'll know. Smaller estates, maybe you don't need a trust. You know, you've got a little home, a car, and a bank account, and a life insurance policy. I would say a trust would be overkill. You know, the will should be able to suffice. And that's a good thing to know when you're, you know, that's why whenever anybody meets with me, and I do free consultations all the time, bring a list of what you own to either myself or to the attorney that you're meeting with. How do you own it? What do you own? Yes.
What rough number would you set for having a trust?
It depends. Usually $500,000 is when it starts to make sense when you do that math. You're right, because that's a good number. We got to know what number. So per capita versus per stirpes. Anybody know the difference? Per capita is by the head. So if I say these 3 folks are my beneficiaries on a bank account, it's per capita. So if I die and 3 are alive, each one gets a third. If one of them predeceases or dies with me, it's 50-50. Most people don't want their estate plans to roll that way. They want it to go per stirpes, by the branch or by the root, down to the next generation. So I would say that if this gentleman passes away before me, he's my son, I want the money to go to his children, my grandchildren. So that's the difference between per capita by the head or per stirpes by the branch or by the lineal descendants. And I will tell you, banks in Florida only do it per capita. So if you go and open a bank account at Chase or Charlotte State Bank and Trust or Synovus or whatever, it's by the head, which usually is in direct conflict to the person's estate plan because it usually says per stirpes. So you could actually disinherit a grandkid without even knowing it. So a limited time or ability to fund a trust. A lot of times I've got people coming in my office, they say, I've got 3rd or 4th stage cancer, Christine, I need to do a plan. Okay, well, we may not have time to do a lot of elaborate planning, so let's just get a plan together, assuming that that person's going to die before their beneficiaries. Concern about incapacity or predator protection. It's a very predatory society that we're in. Florida is known for that, right? I know it. We saw it in our street. We've got our neighbor lost her husband a few months ago. So who starts preying on her? The neighbor next door, who happens to be a felon. Terrific, right? So now the sons have to put up cameras and tell him to stay away from his mother, and he's trying to buy the house out from under her for cheap. I mean, this is what happens. You know, oh, I'll help you with those big garbage cans on recycle day. Oh, I'll go pick up your groceries. I'll take you to the store. And then they take you to the cleaners. They take out all your money. So we see it all the time. And that's why we protect our clients from people like that. Desire for privacy and simplicity at death. Most people don't want to have a big argument. You know, they've already lost a loved one. There shouldn't need to be any more stress. There's enough with just losing somebody you love. So trust can keep things kind of simple outside the courts, quick, easy, not as long and drawn out as a probate situation. Family dispute potential. Most people know who's going to fight. Some people get a surprise. They don't always know who's going to fight over money, right? Or maybe they're fighting over grandpa's favorite watch or the cuckoo clock that grandma and grandpa had at their house. So sometimes they fight over stuff, sometimes they fight over money. But it's good if you plan and you know that in advance, we can work out plans for that. And then, of course, out-of-state real estate, you really do need the trust. It makes more sense. So decisions start with an inventory. What do you own and how do you own it? Who are the beneficiaries? Have you checked them recently? Right? Who's the primary? Who's the contingent? Who's the third? Maybe there's a tertiary beneficiary. Selecting the best administrator of the will, power of attorney, healthcare directives, and trust are essential. You have to know the qualifications. Anybody here retire from HR where they hired and fired people in a business, right? There you go. So you know, right? When you have an HR situation, you have a job description that you float out there, right? And then people send in their resume or their CV, and then you match it up. Same thing. The will, the power of attorney, the trust, those documents are job descriptions. And you darn sure better know the resume of the person who's coming on board that you're thinking of hiring for that job. Are they good with money? What if they file bankruptcy every 7 years? You want them in charge of your checkbook? Right? They have a little gambling problem, right? You got to be careful. So that concludes it. If you have any questions or concerns, I'm available. You can always call or email me. Like I said, I'm open for consultation anytime. Just give me a call and we can book an hour at the bank. So that's not a problem at all. And then the next presentation we're going to do at 4 o'clock will be on DNR versus living will. Any questions from the first topic? Yes. Mm-hmm. Yeah. Gotcha. Analysis paralysis. Yeah, it happens. We call it analysis paralysis. But yeah, absolutely. I meet with people all the time, usually before they see the attorney, and then we get the ducks in a row. I usually do a little summary letter, and then you move on to the attorney, let them draft the documents, which they do a good job, and then I'll read the drafts, you read the drafts, mom and dad read the drafts. Then we make sure they're right, tighten up anything that looks a little, and then they go back and execute. And then I help you fund it. Because that's the other thing. If you have a will, how do you fund your will? You don't put any beneficiaries on anything. Because once you start putting beneficiaries on your assets, you trump your will or trust. You bypass it. So that's important that when you have a trust, like when we developed our trust, it took us about a week to fund the trust. We had to go change a few beneficiaries around, and we were good to go. So it can be done, and it can be done in a short period of time. But you have to know what to do, how to do it, and what assets go where. You don't want your cars in a trust. You want those primarily in the driver's name for asset protection purposes. So there's lots of things that we talk about. But yeah, happy to help anytime. Use my years, and then get your ducks. And it saves time and money, right? Because when you go to the attorney, it's hourly. It's, package prices. Sometimes it goes a little long. But yeah, happy to help anytime. Any other questions? That was a good one. Good? Okay, we'll conclude, and then we'll get started on the next topic when the lady in the red T-shirt tells me. We're done. That was good, right?